burdens placed on the challenger, and in almost every single case, the government will prevail. This is why if you're a government lawyer, you try to push the case to a rational basis standard. That's what you actually want to apply. We'll talk about sex discrimination next week, I think, a little bit more, but the burden's a little bit greater. The interest does not only need to be legitimate, it's got to be important, right? So if like legitimate's over here, maybe importance over here, right? It's sort of a more demanding standard. Okay. And in terms of the fit, instead of just a rational relationship, there's a substantial relationship. All right. What's the difference? Well, rational is like here is like, is it even possible this makes sense? Okay, that's rational. Versus, okay, that makes some good sense, right? You have to have some rationale that actually coheres. But then we get to the strict scrutiny standard. And here I want to just focus on this for a minute with the affirmative action cases. The canonical statement is that the means must be narrowly tailored to compelling governmental interest, right? So actually I have to make a correction. I said something that was wrong yesterday. I said the only compelling interests that were upheld were core motto and affirmative action. That is, core motto national security and affirmative action in Bakke and Gruder and Gratz. I said those are the only two. I was wrong. I forgot this one. I didn't remember until I read the case last night. So even Josh makes mistakes. It's true. We all make mistakes. There was a case called California against Johnson from 2003 or 4. This was a case from, as the name says, California, but involves a prison. I want to ask this. Prisons can be very dangerous places for the inmates, right? We all agree. Very often, there are gangs in prison. And when gangs start fighting in prisons, people get shivved, they get murdered, guards get held hostage. It's very dangerous. And as you can imagine, in California, there are many rival gangs, the Bloods, the Crips, the Latin Kings, and so on, right? It is probably a bad idea to put a Blood in the same cell as a Latin King, right? Because there'll be race wars. So what did California do? California decided to segregate people based on their race. Put all the black inmates here because they were probably members of one set of gangs, and the Hispanic inmates there because they were members of a rival gang. Now, of course, was every member of that racial group a gang member? A gang member? Of course not, right? They didn't know that. But they temporarily assigned cellmates when you first arrived for new prisoners based on your race. So they figure out, okay, this guy a member of a gang. Okay, it's not a gang member, whatever. It goes to the general population. So the question was this subject to strict scrutiny? And the court held that it was. Right? They said this is a racial classification that must review a strict scrutiny. They didn't actually decide whether the policy was valid, but they did say, or at least they hinted, that in a prison, keeping safety in a prison is a compelling state interest. So I didn't mention it because I just don't think it's a very important case, but I have to always correct the records. I try to be truthful to you all because this was mentioned in the Harvard case. All right, so at least there's 2 or 3 interests that everyone recognizes as compelling. It's unlikely there are more. So by very definition, the compelling interest test is going to be really hard to satisfy because there are not many of them. But then we get to the idea of narrow tailoring. And what does it mean to be narrow tailored? And if you think of the Bakke case as an example, Justice Powell said, well, the quota system's no good, right? Because it's mechanical. If you're in this race, there are 16 seats. Race is used as a very important factor. A lot of race is being used. But then we go to the next case, Gruder and Gratz. In Gratz, the undergraduate, if you were a certain minority race, you got like 20 points added to your score. The court said that's no good. That's not narrowly tailored enough, using too much race. But it's aha. The law school uses race as one of many factors. At least they said they did, right? And that is more narrowly tailored. You're only using a little bit of race and a lot of other stuff. At least that's what they said. So in the law school case, the Gruder case, they found there was sufficient narrow tailoring. Now I didn't assign the Fisher case, right? But this issue came up as well. How much deference is due? So in other words, when the government says our policy is narrowly tailored, can you say prove it? You know, how much are you actually using race? How are you using race? What's a critical mass? Gruder basically said, we're not going to defer to the university. We will decide for ourselves. But then Fisher came in and said, yeah, we'll defer. In the interest of academic freedom, we'll use deference. That was the thing that was overruled for the most part in the Harvard case. But with the exception of affirmative action, at least before the Harvard case, this is a very demanding standard, and it's almost impossible for either side to satisfy it, right? The government is going to lose in a strict scrutiny case. The government is probably going to lose a strict scrutiny case. All right, everyone sort of get that overview of the 3 tiers of review. They're called 3 tiers, 3 layers, 3 levels. You'll see, by the way, a tier is like a level of a cake, right? A 3-tier wedding cake, right? Someone said, Josh, what's a tier? Not like a teardrop, right? It's a level of a cake. Actually, a teardrop is a gang thing, right? So we're bringing it all together. Oh God, how many students did I fail? Put a teardrop for each time. No, just kidding.
Have you ever failed anyone before?
I have.
How many people?
Not many. It's been a while. I mean, look, it's been a long time. You have to. I'll tell you exactly what happened. I didn't used to take attendance. I did not use, because I thought, oh, you're all adults, and it's not my job to keep track of you. And then students took advantage of me, and they never showed up to class. And then perhaps, and this is before Zoom, by the way, unsurprisingly, if you never come to class, you don't know the stuff. So yeah, that year I think I failed maybe 1 or 2 people, and they started taking attendance. I shouldn't have to, by the way, sign in for attendance. As I remind all of you who haven't signed in yet, 16 of you. But you have to really show you've learned nothing this semester to fail. It's not a pleasant feeling, but for the most part, this is a true point. I'll make this point. If you're a first-year law student and you're failing a class, that might be a signal that this is not the right thing for you, and that I'd rather you get that signal loud and clear as a 1L than have to dump in 3 years of tuition and fail the bar. Actually, so this is a true story. So in property, I always give a spreadsheet of bar passage. I haven't done it this year because those are second years, but the relationship between GPA and bar passage is pretty close. And I don't know the exact numbers, but if your GPA is above a certain point, you're right at 90% pass rate in the bar. If it varies, but it's above a certain point. I don't have the exact number, so I don't want to make it up. But if you're below a certain level, you're at 50-50. And I showed these statistics. I actually had the person, our numbers guy, give statistics for the bar, and I told my students this a couple of years ago. So yesterday, the Texas results released for the February bar, and let me just read you the email. It was a little bit gloating, but what was her name? Just a little bit gloating. Okay, Professor Blackman, I was in your Proper 2 class in spring 23 when you shared the statistics showing bar passage compared to GPA. I am happy to share that I passed the bar on my first exam. Thanks for the motivation. I am proud to be the exception to the statistics. You are an a-hole. No, but I'll take the point. I'm like, and I replied, there's a famous quote, Mark Twain said, there are 3 kinds of lies. Lies, damn lies, and statistics. Twain didn't actually say it was Disraeli, but it's close enough. So it's true. It's not 100%, right? You have to, and with bar pass, I'm not making this up. You have to work about 50 to 60 hours a week. We track your numbers with your app, right? We know how many hours you're logged into the app with your videos. If you work like 50, 60 hours a week, there's a formula. You will pass almost at 90%, right? If you do the work, you're going to get there. The other factor, and this is not pleasant, is undergraduate GPA and LSAT, right? Mostly LSAT. We know when a law school class starts based on their LSAT, what the bar pass would be 3 years hence. So, I'm not going to make this up. I'll just give median LSAT, right? Right. When our median LSAT is about a 154, that is not the average, but the middle of the class is about a 154. We're like in the 80s. We're in the high 80s, right? It's like if the LSAT of 154, we're like 85% to 90% pass rate. We're happy. If the LSAT is a 153, we're like low 80s, like 82 to 85. If the LSAT's a 152, 3 years hence, it's like between high 70s, low 80s. If it's a 151 or 150, we're mid to low 70s. So despite all of our efforts to teach you all as hard as we can, if the entering class profile is below a certain point, we know what's going to be. Now we say, Josh, why don't you admit smarter students with higher grades? Well, yeah. So the challenge, of course, right, is twofold, right? One, we are a private law school. We're tuition driven. We have no university, right? If we don't have students paying tuition, the lights don't stay on. I'm not being facetious, right? The way the school operates is tuition. Like not like UH, we're like, oh, we have a shortfall. Okay, main campus writes you a check for the legislature. We don't have that. So we have our own thing. The second element is that different years are more competitive. So this year, actually, there is a significant rise in applications. People are not necessarily good. People saying, wow, the economy is not great. Let me go to school instead, right? So yeah, woo, right? You're all graduating, woo, right? But some years, there's a lot of applicants. We can be more selective. We can pick people with higher LSATs. Other years, it's not feast, it's famine. And there are few applicants. And we have fewer applicants, fewer people take our offers. And we have what's called a lower yield rate. There's fewer people accept the offer to attend. So when that happens, in the lower yield rate, sometimes the grades dip. So then you have to make a choice. Do you accept people with weaker credentials, knowing the bar passage will drop in 3 years? Or do you take a financial hit and you lay people off? Do you fire people? Do you cut programs? Right? It's a zero sum game. Fewer students mean you have fewer services. There's no way around it. Why don't you just attract smarter students with scholarships? Well, that costs money, right? When you what they call discount tuition, when you give a scholarship, right? That's less revenue for the school. So the faculty, we think about this a lot. Like we think a lot about what is our target, what are we trying to hit? But sometimes you make offers and people accept more than you expect. And sometimes we make offers and we get a low yield or people don't accept it. So it's actually a perfect segue for today's case. Assembling a class is not easy. And then maybe when you're at Harvard, you just basically this never-ending supply of like geniuses who want to come to you. Not all schools have that luxury. And I don't mean that to disparage anyone in this room. I think you'll be more successful than most Harvard kids. They don't always do great. Trust me on this one. They have their own struggles. There's nothing special. Yes, ma'am.
One last comment. In our bar preview class, they were like, we heard everyone in this class struggles on call law.
Was that my fault?
No. They were like, we heard you had a professor. She was absent a lot. And they were like, we're going to bring in someone to teach you on call law. And so I thought that was kind of funny. So pay attention to this class because apparently the last bar group did bad on the bar, they think, because they didn't know call law and it was tested heavily.
Okay, well, hopefully you know that stuff. What's ironic, though, and this I didn't want to pivot from the admission, the bar, they test most about First Amendment, which is bizarre. They will test very little on stuff I teach you. Why are we paying attention? If you actually look at the breakdown of topics, we have a 2-hour class for First Amendment and 4 hours for everything else. Almost like I think it's like a third or fourth of the exam is actually First Amendment stuff for common law questions. It's almost backwards as you think. So yeah, maybe it won't be helpful for you. But anyway, there it is. But my point is, I've yet to see much of a relation between 1L and bar passage. It's kind of a myth that if you really learn something your first, you'll remember it when you graduate. You won't. You won't. Trust me, you've learned so much. Think about, can you remember your first week of course, what you learned? Maybe your second week, right? This stuff just vanishes from your brain. And the month before you take the bar is like this like compression, like you're in a cooker and you're just compressing it and you're learning it very quickly. That's where it counts. But to be sure, I mean, LSAT is not your destiny, but there's a good relation between LSAT and bar passage. It's there, right? Just your ability to cram for an exam and perform on an exam. And the bar and the LSAT are not the same, but it's a standardized test, and some people don't do well on standardized tests. It's just that's how we all function. Fortunately, it's a pass-fail. It's not like you have to get a score like 150, 155. It's a pass-fail. But there's a cliff, right? You have to get enough points to pass, and then you're good. But if you don't get to that level, you're on the other side of the cliff. You fall off. And that's the sucky one. Even just yesterday, or I think 2 days ago, the bar results released. People who didn't make it through.
20. There was like 19 or 20 people, I think. Yeah, I know someone who didn't make it through.
Did this person do all the hours?
I don't know if she did.
That's almost if you have the aptitude and you put the hours in, unless you get sick or your grandmother dies or you have a car, right? If stuff happens, stuff does happen. But generally, if you put the hours in, you should be in a position to pass. And it's a struggle. You'll see at graduation, the dean gives his entire speech of celebrate today, study on Monday. We actually used to have graduation a week later. We pushed graduation a week up so people would start studying earlier. I know it sounds crazy. We actually moved the graduation closer to exams. So you won't even have your exam scores the time you graduate. Like we moved graduation a full week earlier to avoid this. Oh, I graduate next week. No, you start studying that Monday after graduation.
They're actually going to start studying after finals.
Steven, yeah.
Actually, quick question on that. Let's say like someone has like a borderline GPA and they graduate, but then their grades come back and then they don't have the GPA required to graduate.
Oh, it happens rarely. So not this affects anyone in this room, God willing, right? But if you're on the cusp of not graduating, you know in advance, and they may not certify you to sit for the bar that cycle. We have this policy, and it's a policy that I don't know that I agree with, but we have this policy where, and Addie knows about this. When you are in your final semester, if you're below a certain GPA, you have to take a basic bar class, and if the director, if the director says you're not ready for the bar, you don't pass that class, you don't graduate. So the school has to certify, is this person ready for the bar? That's one thing the school does for the state law examiners. So if we think you're not ready, we say come back again. Now the problem is, and this is why I have a difficulty with it, it's not clear to me that if they take it 6 months later, they pass at a higher rate. In fact, one of the reasons why our February passage is so low is people deferred in July, take in February, and they're still not ready. In other words, if you weren't ready in 5 months, if you weren't ready 3 months after graduation, we'd be more ready a year after graduation when you've had to work and do other things to keep your lights on and keep being fed. So I'm not sure the deferral actually helps. I think it just delays the inevitable. But I don't know. That's not my thing.
How did COVID go?
Oh, it sucked. No, it was terrible. So the what they actually did for was this the March of so COVID happened March of 2020. So the February bar had already happened, right? So that was already done. But I think the bar, I guess it would have been July of 2020. They actually did it at the Hilton Americas Hotel. They booked one hotel room for each student, and your hotel room by yourself with your door open. And they actually searched the rooms, make sure you didn't have a contraband or any materials to cheat with. Like you had to put all of your belongings like in a suitcase and they taped it or something, like a seal on it. But yeah, they actually pulled it off. I don't think Texas ever did a remote bar exam. Other states did, and it was a disaster. California just had a remote bar exam and all their systems were crashing and like basically half people couldn't finish. Can you imagine you couldn't even submit your exam? Oh, it was terrible. It was really weird. Some states caved and they gave just provisional licensing. We just going to admit you by virtue of graduating law school.
Oh.
Louisiana, I think, did that. Maybe one to it. It was actually, I'm remembering maybe wrong. The Louisiana Supreme Court, I think the Louisiana Supreme Court, I think, had a 4-3 decision saying we will just adopt everyone. It did everyone. California did that. A couple other states did that. But Texas, they actually pulled it off. Maybe it was in July. Maybe they postponed it till August. They waited a few months, but they had it like in Hilton, every hotel in a city. Like they booked out the entire hotel. Hotels were empty. Every kid had their own room. And you took in a room by yourself. And I guess,
And have we got the results from like the kids who were in
One
law
else?
school in COVID? Like I guess that's
Yeah, that was the class of 2023, and that's the class of 2024.
Okay.
Yeah, and I guess they graduated last spring. We had 90% pass rate. They did okay. But again, I love your 1L professors, but it's on you. It's not on us. And this is just the hard thing to say. Bar passages. How good of a student are you? How much are you studying? How hard are you going to work? We can do whatever gifts in the world. We can give you the wisdom and the knowledge, but you have to push it through. Every now and then a student says, Professor Black, I'm taking the bar next month. Can I be proper with you? I'm like, oh my God. If this is what you're asking, you're spending your time poorly, right? If you're going back to your 1L notes during your month for the bar, then time is not being spent in an appropriate fashion. This is not a good use of your time. I can't say that to them because yeah, sure, whatever you want. I don't want to spook them out, right? It's also a confidence thing. You have to keep your confidence. If you get spooked at and you lose your confidence, that's also bad. So you have to keep their confidence up. Like they have they have these lists like, here, call these students to give them a pep talk. We do all these things to give you motivational talks. We love you. We really do. There's a lot of things we do for you. You'll never know. Okay. I haven't done any of my material yet. All right. We good? All right. So let's go to the material, if I may. So, I'd be remiss in knowing the class on Monday was a little quiet, and I can sense it. So there are a few topics every year that I think are a little bit more, let's just say, sensitive, that people sort of connect to more. One of which is abortion. We'll do that the last 2 classes of the year. Obvious reason why that's personal. Another one's the gay rights cases. We'll do that as well. Although that's become less over the years. Before the gay marriage ruling, that was a much more hot issue. I just see from my perspective, that's kind of just pettered out. It's just not quite as salient as it was even 10 years ago. Okay. And the other one's affirmative action. And I think this topic in particular creates more sensitivity because it affects you all, right? To take either position that Justice Thomas does or Justice Jackson does implicates very core values of how you see yourself, how you see the world. And I think these opinions, in particular, we'll read today, are like from different universes, right? You read the Justice Thomas opinion, and it's like, okay. And you read the Justice Jackson, it's like, okay. It's like, are you living on the same planet, right? Are they in the same realm of how they see the world? And you all have your own views, and it's important that you do. But what I care about most is if you get the justices and their doctrine, right? If you get, why is it that Chief Justice Roberts sort of writes what he writes? Why does Justice Jackson or Justice Sotomayor or Justice Thomas write what they write? That's sort of the sort of lessons that I want to sort of get home to you. And if you could sort of just focus on sort of the legal issues in that context, I think it'll be a little bit easier to cite. It's just my humble opinion. But I understand this is a topic that has some challenges. All right. So let me start by just recapping where we were before the Harvard case. I'll just go with the Harvard case just to make it easy. I know UNC was there, but I was in North Carolina last week, and it's funny. I was there the day after UH beat Duke. I went to Duke Law School, and they're like, right? Like, I don't have any loyalty. Let me go to UH. I don't care. But then I was watching the UH game the last minute. That was hard to watch. What was the thing where he jumped up and dropped the ball? Did anyone explain what happened? That
So he jumped up with the ball, and once you come down with it, you can't touch it.
no, but why did he pass it? Why did he come down with it?
He was going up for a shot, but then we'll think him in really high. He's going to block the shot.
You couldn't pass it. There's nothing else,
The shot was for him to take.
and it kind of just dribbled out, and then the clock.
Because if he touched it, it would have been a turnover.
Yeah, it was a turnover.
So he was hoping someone else would touch it and get it back. Is that? I was just watching, like, what the heck is that? I was trying to figure out that. Anyway, thank you for explaining. I couldn't get that. No, it's just anger. Turned off the TV. I was like, whatever. Although, totally selfishly, I don't like when Houston wins championships. I have to cancel class. When there's a parade, we cancel class. So,
Rockets.
that's in June. I don't care. When the Astros win the World Series, I have to cancel class. Like, oh man. So sorry. I tell you, we have a lot of stuff we have to cancel when there's a parade downtown. Anyway, so let's review where we were. Right in Bakke, the court split 4-1-4, which is a very unusual split. Right. There were 4 justices who said that the affirmative action policy at Davis violates the statute, Title VI. There were 4 justices, the liberals, who said, no, this is constitutional and it's consistent with the statute. And then Justice Powell is in the middle. He had this sort of weird opinion where he said, well, the UC Davis policy is unconstitutional because it's a quota, right? It's mechanical. But in theory, at least, this plan from Harvard, right? Harvard, right? This plan from Harvard might be valid because race is used as one of a plus factors, one of many factors. Okay. In the aftermath of Bakke, there was not a clear Supreme Court decision. You didn't really know what the rule was. And in fact, the Fifth Circuit, in a case called Hopwood in the mid-1990s, declared that the UT policy, UT Austin, was unconstitutional because he was raised too much. And that's why we have a 10% plan or 5%, 6%, whatever the number is now. We have a thing where if you graduate in the top X percent of your class, you're guaranteed admission to the state universities. Okay. Then we get to Michigan, right? Gratz was the undergraduate. Please be sure to separate them. Gratz was undergraduate, Grutter is law school. It's confusing because they're both G, and I know that. It happens every people mix them up. But Gratz is undergraduate. In the Gratz case, they gave a mechanical number of points people based on the race, and the court said that violates Justice Powell's opinion, and that's not narrowly tailored enough. But for the law school, they said we use race as one of many factors, plus factor, and they said that's sufficiently tailored, right? The challenge, though, is they said we think that the university can't do this forever, right? The university is trying to achieve a critical mass. And the court says, we hope that 25 years from now, they will not need this anymore. It wasn't like a expiration date, like in a carton of milk, right? But it's kind of like aspirational. Like we hope in a quarter century, right? We're 25 years from Bakke, 25 years from now, that would be 2028, that the government will no longer need to use this policy, right? It's durational, right? It's not going forever. Okay, then we fast forward to 2013 and 2016. There were two cases decided. I didn't assign them because they're not really relevant anyway. They're overruled, more or less. But in 2013, the court decides the case called Fisher. Abby Fisher from Sugar Land was not admitted to UT. That was an unusual case. I say it's unusual because the votes flipped. It's not just Obamacare. This happens a lot. Originally, the votes were to declare the UT policy unconstitutional, even finding that whatever Grutter said, they're using too much race. And the story goes, apparently Justice Sotomayor wrote this very powerful dissent. And she was able to persuade Justice Kennedy to flip his vote. And instead of declaring the UT policy unconstitutional, they said, well, go back down, right? And really apply strict scrutiny, right? Apply strict scrutiny. The Fifth Circuit didn't apply strict scrutiny. So again, apparently Sotomayor convinced the court to flip. So the case goes back down to the Fifth Circuit, but this is not today's Fifth Circuit. This is a very different Fifth Circuit, much more moderate, right? The Fifth Circuit panel basically said to the Supreme Court, screw you, we're upholding the policy again. The court declared the policy unconstitutional and only set a precedent for Texas, not nationwide. That's what the Fifth Circuit said to the Supreme Court, middle finger, we're going to uphold this exact same way. They almost wrote the same opinion, and then it goes back to the court. The case was argued in, February of 2006. No, I might be off. January of 2016. I might be off by a few weeks. It was January of 2016. Okay, why am I making a fuss about the date? Well, when it was argued, there were 5 votes to reverse. Very clear. Justice Kennedy was annoyed. It's like, look, I told you to use strict scrutiny. You didn't use strict scrutiny. Why are you wasting my time with this? But then on February 13th of 2016, a day that I won't forget, Justice Scalia was out in a ranch out in West Texas. He had been traveling a lot. He'd been to Singapore, been around the world. He went to sleep, did not wake up. He died in his sleep. Not for the conspiracy theorists, he died, the pillow was on his face when he woke up. Oh,
My mom thinks like that.
I know. I bet your mom was. Yeah. He wasn't a CPAP machine, which he was not using. No, the thing you have to put the mask on the face. He wasn't using it, so he had bad health. Justice Scalia. He smoked. He didn't eat well. The robe hides. He was big, and it's when you have life 10, you should take better care of yourself. Anyway, that's just my opinion. He was too important to have that lifestyle. He should. His family blames the fact he was traveling so much on his death. It's actually it's a sore point. He'd been in Singapore the week before. Actually, I was in Singapore around the same time. I was talking with his travel partner about where to go, and it was weird. Okay. So when Scalia died, there were no longer 5 votes to reverse. The court was only a 8-member court, Kagan to recuse. So apparently, Justice Kennedy is persuaded to change his vote again, sensing a pattern. And the court basically reversed. They said, well, we're going to uphold the UT policy. And they made a key distinction. They said, we will defer to the university of how to define what narrow tailoring is. If the university thinks this is the best way of achieving their interest, that's for them to decide, and we'll defer. That is the opposite of what narrow tailoring means. Now, narrow tailoring means the government defines it. I actually know the lawyer who argued Fisher too. His name was Will Consovoy, brilliant lawyer. He died. He died a couple of years ago. Very tragic. He guys went to my law school. Brilliant. Consovoy McCarthy. Consovoy, I saw him right after the case was argued, and he was just beside himself. How did this happen? We had Fisher won. They said apply strict scrutiny. We went back down. The court ignored it, and then we lost. And the court just changed the rule, right? The court watered down strict scrutiny in Fisher 2. Okay. So in the wake of Fisher 2, that was in 2016, the affirmative action issue is kind of just floating around. And I told my students every year, you can go to the videos and check, and I said, if there's any case in my book that's likely to be overruled, it's Fisher 2. Right? That was an unusual one. In fact, Justice Alito, in his dissent, said something like, there were unusual circumstances here. And it's not even clear if a 4-member majority is a precedent. I don't think it is. So really, there's no start. By the way, why did Roberts not overrule Fisher 2? Right? Why did Roberts not overrule Fisher 2? I don't think it was a precedent. I think no precedential value, so you didn't have to overrule it. Anyway. All right. Everyone with me? All right. So now we get to Harvard and UNC. In the wake of the Fisher decision, Will Consovoy and his people bring another lawsuit. They create an organization called Students with Fair Admission. Right? Students with Fair Admission. Why is this not, John Doe versus Harvard? Because eventually John Doe graduates. And they didn't want to get to a position where the defendant graduates or the plaintiff graduates and the case becomes mooted. It's basically almost happened to Abby Fisher. So they created this group called Students with Fair Admission. The sole purpose of this group was to challenge affirmative action. Like, that's why the group was made. A guy named Ed Bloom is actually a Texan, helped to bankroll this organization. Really, really influential guy. I've never heard of him. Is Ed Bloom, BLUM. The litigation began before the Trump victory. I'm sorry, the litigation began before the 2020 election. So at the time, it wasn't clear what the 5 members of the court would look like, right? We didn't know if Barrett was going to be there. Kavanaugh was probably in the court, but we didn't know who the members were going to be. The group filed a cert petition in February of 2021, and the Supreme Court sat on it for almost a year. They did not want to decide this case in 22. Why? They already had Dobbs. They're like, we're not doing abortion and affirmative action the same year. Let's just space this out of it. So they basically did the court controls this docket. It's actually very creative. We'll just delay this a bit. And they eventually granted it. So it'll be argued in 2022 and decided in 2023. Okay. The oral arguments in this case were long. So first off, there were 2 cases, right? Why were the 2 cases? Harvard and UNC. Originally, they had consolidated. They put the cases together for one case, but then they unconsolidated them. You don't know why? Yeah.
Is it because Harvard's a private school?
Well, that's true. That's true. But yeah.
It's because they had different, they were suing under different act or different legal standards.
No, it was actually a very different reason. Steven?
I was gonna say one was Title 6, I think, and then the other was
You're not wrong, but this is an obvious reason. The newest member of the court, Justice Jackson, serves in the Harvard Board of Overseers, the Board of Governors. So she recused. And actually, during a confirmation hearing, Ted Cruz was like, so you're going to sit in the Harvard case? She's like, no. But the weird part is she sat in the UNC case, which presented the same issues. And she most certainly was involved in the Harvard case, but she was recused. So officially, she wasn't part of the case, but she was. It's actually a little bit of a controversy. So they had 5 hours of oral argument, 3 hours for UNC and 2 hours for Harvard. That is a lot. That is exhausting. 5 hours in one day of oral argument. In the Obamacare case, there were 5 hours of oral argument in the course of 3 days. Here, they squeezed 5 hours in one day. This is actually one of the things I blame John Roberts most for. During COVID, they stopped enforcing time limits. When William Rehnquist was the chief, if your light turned yellow, he would stop you mid-sentence and say, thank you. Mid-sentence. You don't get to finish your sentence. John Roberts, it's okay. You finish your sentence. Oh, you can go a little bit further. And he's, we use a little more time. And once you have a little bit more time, you're done, right? Because you can never enforce it. So during COVID, you asked about COVID, Chelsea. During COVID, they started doing oral arguments with a telephone. Not even Zoom, telephone. And the advocate would call into a Supreme Court conference line. And the chief did this thing where they had everyone ask orders and question order of seniority. So first the Chief Justice goes, then Thomas will go down the line of seniority. But you basically get as much time as you want. This is a true story. During one of the arguments, you heard a toilet flush. Poor Justice Breyer. You could zapruder this. He actually was eating. He hears food clinking, forks, and a few minutes later, he hears toilet flushing. Yeah, I know the guy. I think it was Cannon Shanmugam arguing a case, and you hear the like, was that a toilet? But they did live stream the arguments, so that was great. So that changed. Now we have live stream arguments thanks to COVID. But then even after they got back, they kept an element to that where basically they take an hour to argue the case or 30 minutes to argue the case for each side, and then each justice gets their own turn. They go as long as they want. And then the chief just invariably gives more time to everyone. So it's went on for 5 freaking hours. It was I listened to the first hour. So I was like, all right, I'm done. I'm good. But from the outset, I'll just kind of just walk through how I heard the case. Roberts seemed pretty clear where he was leaning. He seemed that you're going to be using affirmative action forever. And at one point, it was referenced that if a person lists in their application that they're Asian American, Robert said, you probably should put that in your application because that probably hurts you. So you can see which way he was leaning. Justice Thomas, as you can probably guess from Grutter, was extremely hostile to the lawyers for UNC and Harvard. And he said, I've heard this word diversity quite a few times. I confess, I don't have a clue what it means. It means everything to everyone. Okay. Justice Alito had a line of questions that perhaps not be anticipated is, you have these check boxes, white, black, Hispanic, Asian. What do those things even mean? They are arbitrary. They truly are arbitrary. Hispanic, that's actually the hardest one. It's arbitrary, right? These categories were created by a bunch of bureaucrats in the 70s. They don't actually mean anything. As a person from, Malaysia or India, the same as a person from Japan or Singapore, right? These are worlds apart, right? These are very different cultures. If someone from Afghanistan, that was actually Middle East, Jordan, Egypt, where do they fit, right? Hispanic, is that Spain? Is that only Portugal? What about Puerto Rico? What about Brazil, right? The categories don't define themselves well, okay? Justice Sotomayor made a point which came up under dissent quite a bit. And she repeated over and over again that race was not determinative, that it was only one of many factors. That's the point that she was making. Justice Kagan had, I think, one of the more awkward exchanges you've ever heard in the Supreme Court. So there's a rule in the Supreme Court. If a unfriendly justice is asking you a question, you should never get pinned in. It's impossible to win a case at the podium when you're an advocate. But you know what you can do? You can lose a case at the podium. If you concede a point at the podium that you do not concede in your briefs, you may have done your client a massive disservice. And trust me on this one. Kagan asked a question that I think most people, if they were asked that, would just caved. So the lawyer is a friend of mine. His name is Cam Norris, who's maybe a year too young, but he's a young guy. And she asked point blank, what would happen if after we rule, the number of black students at Harvard dropped to 0? Would that be a problem? 0. That was her question. What's the answer? No problem. Why? The second you say yes to the problem, okay, then what do you do about it? You have to. If the absence of affirmative action yields a 0% African American rate at your college, and that's a problem, what are we going to do about it? Affirmative action. He had to say, no, Your Honor, that's not, we have no problem with that. That requires some backbone because you knew this guy's going to get dragged on social media, right? Because this is being live streamed. You knew he's going to get attacked on every single corner. And I was like, oh God, what's Cam going to do? It's like, he held it. He said, no, Your Honor. And I think he was ready for that question. He knew, you don't know the exact question you get, but you get the general one. I mean, the rule of thumb is if you're at the Supreme Court and a question surprises you, you failed to prepare. There should not be any surprises up there, right? If there's a question, it's like, oh man. I'll give you an example. This was during the gay marriage case from 2014. I think it was either Alito or Roberts asked the Solicitor General, okay, we have gay marriage. What if you have a religious college? Is a religious college required to give family housing to a gay couple? You know what the government lawyer said, the Solicitor General? Top lawyer of the government. He said, no, not yes. He said, Your Honor, I haven't thought about that. I feel that's some thought. The United States government, the top lawyer for the government, because he knew if he answered this question the wrong way, it'd be problems, right? And he said, Your Honor, I haven't given it much thought. I'm not sure. Better to do that than to give the yes or no answer. Don't lock yourself in. And the leader was like, how have you not thought about this? And the problem is there, people mooting him weren't actually on the other side. It's actually a challenge when you're being mooted to people on both sides of the issue, right? You can't have people on your side mooting you. But yeah, the Kagan one, it was an awkward silence. All right. Justice Gorsuch focused a lot on the statute, and I don't want to focus on the statute. That's not really my interest here. Kavanaugh said, well, how about we have race-neutral alternatives? And what were the 3 race-neutral alternatives he proposed? None of them worked, by the way. He said socioeconomic, that people have less money, which would somewhat correlate to race, but not really. Then he said the top 10% plans, which again is more or less based on race. Then he gave a third one, race-neutral approach. He said to the lawyer, Patrick Strawbridge, also a friend who's a good lawyer, he said, what if colleges give a plus to descendants of slaves? Would that be race neutral or not? So he thought of this one himself. And the lawyer said, that's a proxy for race. Who were the slaves? Black people, right? In other words, you're merely just doing it without saying it. But the advantage or the impact of that one would be Hispanics? Nope. American Indians? Nope. Any other group that did not descend from slaves. Then we have the question, what does it mean to descend from slaves? How many grandparents you need or great-grandparents you need? It's actually a question of the countries when you're trying, for countries that don't have birthright citizenship, to trace your genealogy is actually very hard, right? Because you have to find how many grandparents you have, or the guy or the girl. So Kavanaugh abandoned that idea. He didn't pursue that further, but he was trying. In fact, I think he realized, okay, that's not going to work. Justice Barrett, too, was kind of curious. She was a professor, probably involved in admissions. She probably knows more about this than the other members of the court, but she did not seem particularly worried about Bruder. Okay. And then Justice Jackson, too, raised this hypothetical that it's such a long opinion. I gave you only 30-something pages. I could have given you the entire thing. Anyone actually read the entire thing? No. You should. There's such good stuff in the Thomas and the Jackson. Just what? It's so long, I know. I edited it down to the bare bones, my friend, and even then it's hard. But Jackson had some fair points I just want to highlight because I don't have time to talk about it in the case, where she said, imagine that there are 2 students applying to UNC. And the first student says, my family's been in North Carolina since before the Civil War. I am the 5th generation to go to UNC, and I honor my family's legacy. Could you talk about that? Yeah, that'd be fine. Okay, now it's student number 2. Family been there since the Civil War, but my ancestors were slaves. And my ancestors didn't have a chance to go to UNC because of discrimination here. Can you talk about that one? So the majority ultimately said, yes, you could. And this is an important point. The majority of this one paragraph at the end that everyone likes to quote, which is something people like to talk about, is you can talk about your race to the extent it helped you overcome challenges or achieve certain things, but not race by itself. So that was actually a major concession I think Jackson sort of nudged to the majority. By the way, even though there's a dissent, the dissent has an impact on the majority, right? There's always a process of sort of back and forth. And if it gets to the point where the majority says, well, that's actually a fair point dissent raised, they can address it. And the part of the dissent drops out. But you never see the final, you never see the first draft of the dissent. You see what come at the end. In fact, one of the reasons why the Dobbs case was so unusual is we actually had the leak of the draft. So we actually saw what the drafts look like. And there was stuff in the original one that didn't make it to the end, which means they decided to take it out. Like, who saw Josh Craddock last week? In the original Alito opinion, it was actually aligned by a fetal person that the fetus might be a person. And then that dropped out. So things always happen in the mix. Okay. Everyone with me? Everyone with me? Okay. So let's go on to the actual case itself. Who am I up to? Yes, Brett. Oh, up top. Thank you, my friend. So can you just walk me through, please, how Harvard, and we'll do UNC in a moment, how Harvard goes about admitting people? By the way, I never applied to Harvard. I would have never gotten in. I'm not nearly smart enough. I know people go there. They're a different breed.
Yeah, definitely. So they do.
Definitely. God bless South Texas. No, I mean that really. If I was ever in trouble and need a lawyer, I'm not hiring someone from Harvard. I'm hiring someone from this law school. I mean that. It whatever. Go on, Brett.
Sorry, yeah.
We're gonna follow Black. I'm in trouble. You need help. Yeah, you know what I mean. Go on.
They did it. There's like steps to it. So there's like a 4 or 5 step process. And so it'd go to a reader who would evaluate these categories like their academic, extracurricular activities, stuff like that. They would be given a rating.
Mm-hmm.
And then within that, they do take race into account. And then once they pass this first section, then they'll go to subcommittees.
Correct.
Where the subcommittees will meet, talk about other things, but they also would take race into account.
Yes.
They went to a third full committee hearing, and the goal there was to make sure that Harvard didn't have the academic drop-off of these minority students.
Yeah.
And there again, the racial composition of them were disclosed to students. And then they did the lopping period.
Lopping. Yeah, cutting off. Yeah.
Right. And so they only contained 4 pieces of information that they looked at. That was legacy status, if they're an athlete, financial aid, and race.
Correct. Very good. So again, the precise mechanics here are not terribly important, but what's important to realize is that at every stage the race is considered, and at the very end, when they're cutting people, making the final cuts, they consider legacy, whether you're an athlete, financial aid, and race. And I think Marilyn, I think you mentioned legacy last week, right? So legacy and race are considered like among the final things that are decide whether you admit or not. The UNC one, and let's just be nice for a minute, right? UNC is not as competitive as Harvard. We can be honest here for a moment. Also uses race at each one. Now, this wasn't in the opinion I gave you, but there was a lot of discovery in this case. And I'll tell you something for discovery. Don't put something in a text message ever, unless you want to come out in discovery. Don't put stuff in an email unless you want to come out in discovery. There was some bad stuff in discovery. There was one of the admissions directors basically said, "Oh, he's just another Asian." Yeah. And no one said, "Yeah, we need more blacks," right? There was stuff in the emails that was pretty damning. And the school says, "Oh, these were not following our policy," right? That's not. They were not acting as we instructed. Okay, right? So the school ran away and said, no, that's not what we meant. They took out of context. That's not what the email meant. It's just another Asian, right? Plays piano, good grades, just another Asian. Basically, that was the import of the Gorsuch went to town with this in the arguments. But there was a full trial. And the numbers here are actually comparable to what were at UNC. Right, so in the top academic decile, that's basically the top 10% of grades, the admission rate for black students was 80%, and for white students was 70%. In the next decile, again, 80% of black applicants, and about 60% of whites and 50% of Asians. And the third decile, 77% of black students, and 48 white, 34 Asian. So it's comparable to UNC, to University of Michigan. In the relevant period that Justice Jackson focused on of so-called of the excellent candidates, the admission rate for Asians was 98%, and the admission rate for black students was 97%, but there were only 2 black students rejected in the same period. So it's a smaller pool, but virtually all of them were being accepted. Okay. All right. So everyone just get the background, right? There wasn't much dispute that the numbers were there. Okay. So then go to footnote 2 of the opinion. I don't know what page it's on. It's on 440 something. You want to just have the page number shouted out? Footnote 2 of the majority opinion. I'm sorry? 446. Thank you. Just go to 446 and look at footnote 2. And this is a John Roberts Blue Plate special. Now, a couple of people earlier, I think Stephen and a few other people mentioned this point. The 14th Amendment applies only to UNC. Yeah, I know, right? It's a state action issue, right? This is what civil rights cases. So UNC is a public university. the 14th Amendment applies to the public university. Title VI is a statute. Title VI applies to any institution that accepts federal money, which is basically all of them. We accepted Harvard, UNC. So Title VI applies to both. The 14th Amendment does not apply to Harvard. How does John Roberts fix this? He's like a magician. He's like, look over there. It does stuff over here, right? You know, it's distraction. He distracts you. He says, well, in Gratz, the Michigan case, the court said discrimination that violates the 14th Amendment also violates Title VI. They said that. They didn't actually care, right? But they just said it was kind of an aside. He says, no one asked us to reconsider this. So too bad. We're going to judge this under the 14th Amendment. He made the standards the same. They're not the same language. The 14th Amendment says equal protection to laws. Title VI says no person should be excluded on the basis of race. Those are very different standards. He just makes stuff up. This is like, I remember reading, I was like, oh, Johnny boy, he did it again, right? In a footnote too. He buried the footnote. So going forward, the standard for Title VI and the standard for the 14th Amendment are the same. I can tell you that in the lead up to this case, private schools like, oh, we're going to be fine, right? If they read a 14th Amendment, we'll be okay, right? No more. I actually made this point at a conference maybe 15 years ago. I said, you know, you might think state schools are exempt, but I think private schools are subject to the same standard. I'm like, no, that's not right. And they said, I'm wrong. Okay, here it is. So under the law now, UH and Texas Southern, South Texas, public-private, make no difference. We have the same standards for admissions. And oh, by the way, does it apply to other things? For example, admission to law review. Oh yeah, a lot of law schools had affirmative action policies for the law reviews in court.
For law review?
Oh yeah. Oh yeah. Does it apply to hiring of faculty? Oh, this is one that will go nuclear. Look what Trump's trying to do with universities. You want to see legal hiring practices? Go look at law schools hire. It's gotten better. I'll say that much, but it's been pretty bad in the past. Yeah, let's leave it there. Yeah, it's good. There's gonna be a lot of discovery for law school hiring. Not here, not so bad. Other schools, it's pretty overt. They say we are hiring a person of this race for this position. It's pretty explicit. Stephen?
I think like right now, Trump's kind of doing it to a lot of law firms.
Oh yes, law firms also cannot discriminate. Law firms had lots of hiring practices. Say we want to hire fellows of a certain race. It was overt, right? I mean, this is actually a problem. Even in the wake of the Harvard decisions, law firms said, "Oh, this only applies to education admissions." That is not a prudent judgment. If I was an attorney advising a client and I said, there was a clerkship program that our school participated in. For the longest time, it was called the minority clerk program. I actually boycotted it. I wouldn't participate. I said, this is illegal, right? We can't do this program. It's illegal. And they ignored me. And we actually got a complaint against us from the Department of Education. So, I think a lot of people discounted the decision. I'm like, we can't do this anymore. And we're not going to do it anymore. So, yeah, the ABA basically had to rewrite it, to change in all these ways, but it was what it was. There were law firm fellowships. They would give fellowships and scholarships based on race. Even at this school, we had scholarships based on race. We had to cancel those, right? We had to scrub them. I was on the committee years ago for the financial aid. I was like, we can't do this. It's illegal. And anyway, yeah.
I received one of those.
You did?
Is that why it doesn't happen?
Is that why they changed the diversity center to like a really different?
Yeah, they renamed it. Yeah. I think, and it's there's dislocation, right? So the money will now be given to a student of, how they phrase it, who face adversity or something like that. There are locutions that they use to sort of do what they want to do. But look, I mean this. I think schools have now sort of gotten the memo that they have this new decision they have to comply with. It's a live issue, right? It is a live issue. And I think everyone's doing their best effort to now comply with it. It didn't happen right. Well, here actually I think happened right away. At other schools, they basically, Erwin Chemerinsky is a dean at Berkeley, who's actually a good friend of mine. They said, just don't say out loud what you're thinking. Just do it quietly. Don't put it in an email. Don't put it in a text. Just say it. And he was mostly joking, but not really. He's like, I don't want this coming in a deposition. Right? Yeah. All right. All right. Let's move on. All right. So the court's analysis here, right, covers a lot of the cases we've studied, if you notice this. So Chief Justice Roberts says the early cases embrace the transcendent aims of equal protection. By the way, he's a good writer. Roberts is a good, you want to see good legal writing? You might hate this opinion. It's written so well. So this is what I say, when Roberts believes what he's doing, he's on fire. When he's having some sort of compromise, even he doesn't like, it's just garbage, right? You can tell Roberts doesn't like his work because it doesn't read well. This is an opinion that he put a lot of passion into. The transcendent aims of equal protection. He cites what cases? Strouder and Yikwo, right? The cases where the court ruled in favor of the 14th Amendment's equal protection guarantees. But then later cases, he says the court failed to live up to the clause's commitments. What does he cite? Plessy. And he says the court played its own role in that ignoble history. And he's right about that. And he said separate but equal would deface much of America. What a good choice word, deface. Basically take away the face of the country. You're right. And then there was half a century of separate but equal. But then he says separate cannot be equal. Separate cannot be equal. He says we overturn Plessy and Brown. Not exactly, but more or less. And then he used this phrase, I think it was actually very well put. He said, we set firmly on the path of invalidating old de jure. De jure, D-E-J-U-R-E. Do you know what that means, de jure? By the way, you know, de facto versus de jure, do you know what that means? Right? De jure means according to law. De facto means the actual facts on the ground. So what you're saying is we got rid of legal discrimination, but on the path with all deliberate speed. Then he goes to Loving. And he has this one sentence. He says, eliminating racial discrimination means eliminating all of it. And he had a case about 10 years where he said the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. It's almost a tautology. But when Roberts, again, this is an issue that he cares about. When he was a young lawyer in the Reagan Justice Department, he criticized Bakke. And he tried to overrule that case as a young lawyer. So he actually cares about this issue. The other issues he doesn't really care much about. This issue matters to him. Okay? Stay with me so far. All right. Grutter said we apply strict scrutiny. So you must have, number one, a compelling interest, and number two, narrow tailoring. Okay. So here's a question. Does the court actually overrule Grutter or Gratz?
Like saying it?
I thought
It feels like they did.
Stephen?
Well, I don't think they do because they literally cite Grutter for the strict scrutiny test, so you can't overrule it if you're using the test.
Yeah. So what's interesting here is the plaintiffs wanted to overrule Grutter and Gratz and Fisher. Does the court ever use the O word, overrule? No. So then here's my follow-up question. Why couldn't Harvard just say, okay, we'll do what Michigan Law School did?
Why couldn't Harvard say what?
Why can't Harvard just adopt the exact same policy that Michigan Law School did that was upheld in 2003? Yeah, Trent.
I think it's because I think the concurrence points it out, like they basically overruled, like even though they didn't overrule like maybe the reasoning, they overruled like what the outcome was.
Yeah, Stephen?
Well, isn't it also because they said that test was like supposed to last around 25 years, and now it's time to
Right. So this is another John Roberts blue plate special. By the way, you know what a blue plate special is? If you go to like a diner, it's like whatever they just whip together, they put on a plate and they sell it. That's a blue plate special. That's what John Roberts. He just whips stuff together. It's not, I won't say misleading, but he never quite shows you the ball. In all regards, Bakke, Grutter, Gratz, Fisher, overruled. Right? If you were a lawyer and you went to court and you cited those cases today, you'd be like, why are you citing these cases? That's not the law. The law is a Harvard case. But John Roberts never says it. Now, I'll defend Roberts for a minute. I can do that. I can be a good advocate. Right? Grutter said you apply strict scrutiny, and it also said there has to be an end point. There has to be a stopping point. So maybe on its own terms, Grutter self-destructed. You know, like you ever say, like a Mission Impossible message will self-destruct in 25 seconds, right? Maybe, in fact, Grutter, self-destructed. That just it could not exist any longer. Maybe it is the fact that the university was not able to justify why it needed to use race at this point in the world. Jackson Sotomayor will disagree with that vigorously. So I can defend the majority, but I think the more candid thing to say is that Fisher is overruled and Grutter and Gratz overruled. I think you really have to say that. Okay. So I want to get Michael's hand up.
Yeah, so like whenever we read those, I remember like seeing that, and it seemed like the 25-year stuff was just something that he kind of just mentioned in like passing, and it didn't really seem like.
Oh, yeah, right about that.
Yeah, I don't want to use the B word because I don't know.
Oh, dicta?
Yeah.
You can use it. It's okay.
Might be dicta. So like, I guess I don't know why you could. I mean, you can just do that, I guess.
When you're Supreme Court justice, do whatever you want.
Yeah.
Alex Kaczynski once said, being a judge means never to say you're sorry. Of all people, he was allowed to talk. Look, the court often does this where the overruled precedent, not saying it. They call it a stealth overruling. It's actually a name for it. The court does this a lot. We'll say, we're not overruling this case. We're just going to redefine it. We're going to clarify it. We're going to explain what we meant. Yeah.
Is that like kind of what they did when they didn't like explicitly overrule like Plessy, for instance? Because you said like they didn't actually like.
Well, they use the overrule rule. Well, you know what? Yeah, I guess it's an example because they never said we overrule Plessy. They said the principles of Plessy, have no application to school education. So that's not an express overruling. I think that's right. It's rare the court says we hereby overrule a case. You know where they actually did that straight up? Dobbs, abortion. The court said with no hesitation we overrule the Roe decision in Casey. They said it clearly. Chief Justice Roberts would not have overruled Roe, but the majority did. Yes.
It feels like this is just coming down to the fact that they, like in Ruder, they like not explicitly, obviously, but they didn't want to like settle on whether diversity is something that is like, I guess, needed from affirmative action, and that's why they pushed it off 25 years. They're hoping maybe.
Well, let's get to the interests, right? What are the interests that Harvard wants to pursue? There are 4 of them, right? They actually try to break down, okay, you say there are these benefits of having a diverse classroom. What are those benefits? There are 4. Number 1, training future leaders in the public and private sectors. Number 2, preparing graduates to adapt to an increasingly pluralistic society. Pluralistic is just a synonym for diverse. 3, better educating its students through diversity. 4, producing new knowledge stemming from diverse outlooks. What does Roberts say about these 4 items? He says, these are not coherent for purposes of strict scrutiny. How can any of these goals be measured? Right? How is the court to know when leaders have been trained, whether the exchange of ideas is robust? Right? When there's enough innovation and problem solving. These things can't be measured. And what Roberts is saying is with strict scrutiny, if you say there's a compelling interest, you have to measure it. How do you know when any of these things happen? These are just kind of academic concepts, which we can talk about in abstract terms, but without any concrete facts. The important point, though, is there's no deference, and this is where they overrule Fisher. Fisher said, we are not administrators, we're not university presidents, we will defer to this. By the way, who was the dean of Harvard Law School? Elena Kagan. She knows how this stuff works, right? She understands how these things operate. So I think this was a very personal case for her as well. By the way, there was a question she should have recused because a Harvard case, she was in Harvard when this policy was created, but she didn't recuse. Because the interests are not sufficiently defined, right? Robert says this is not enough for strict scrutiny. The interests simply are not compelling. So for basically half a century, the court had said the benefits from diversity are a compelling interest. Is that true any longer? I would say no. So did Roberts overrule Grutter and Gratz? No, but he rejected the premise of the strict scrutiny analysis. He said this is no longer a compelling interest. Maybe it was at some point, but at this point, you can't tell us what you're trying to achieve. It doesn't work. Michael?
So would it be more correct to say that it like covertly overruled Bakke then, since it just disagreed with the premise that Powell had?
Well, to be clear, right? To be clear, Bakke was only a one-member vote, so it wasn't actually majority. But Grutter adopted Bakke. So it overruled Bakke, which overruled Grutter, which had embraced Bakke.
Yes.
Okay. Yes, ma'am.
So is this like, could this be utilized in the initiatives today of rolling back DE&I and all the things like that?
Oh, yeah. Yeah.
Since it's no longer compelling interest.
Yeah.
It's not
No.
being measured.
I mean, what's interesting is that Harvard decided, the case decided in 2023, so almost 2 years ago. In the wake of this decision, I put this nicely, all these law firms came and advised that, oh, you don't have to change anything. All you have to do is just read essays. Everything else is the same. Just read their essays. And basically all these law firms said, oh, look, you can just do the essay thing. And I remember saying, this is not right. And now the Trump administration, we're going to enforce this. Now, you may have never heard of the Department of Education. Maybe you've never heard of it, right? This is an important group that does a lot of things. One thing you do is they can withhold funding. Go to a newspaper today, right? The administration is looking to withhold billions of dollars from Harvard for, among other things, their use of affirmative action even after the Harvard decision. And saying, look, you are violating the Supreme Court decision. We're going to withhold money from you. So a lot of universities have, I would say, made deals, but they tried to work out deals, and I think we'll see where this winds up. This is very much a live issue. But you're right, Chelsea. A lot of DEI centers, even at this law school, they sort of changed their name, they rebranded. Texas as well, the state legislature banned DEI as well at state institutions. So again, this is an area that has shifted significantly the last couple of years. I think the Harvard case was sort of leading the pack. If this case came out the other way, I think it'd be a very different world. Yeah.
Can we talk about more about its application to like private and like for law firms?
Sure. Right. So law firm hiring. Many law firms have what are called fellowships, where they will hire law school graduates to work in kind of these, it's not quite an associate position, but kind of like a 1 or 2 year fellowship where they get to do like pro bono work and get to kind of do public interest stuff with like a law firm salary. It's a good gig if you get like a Skadden fellow, right? Skadden Arps. A lot of these firms have these, and only people of certain racial groups are allowed to apply. They're very overt about that. Shortly after this decision, Ed Bloom, the same guy who brought this litigation, sent letters to all these firms saying, you cannot have these policies anymore. These are illegal under Title VI, right, and other civil rights statutes. Some of the law firms basically caved right away. They said, okay, anyone can apply for fellowships. Other law firms said, we're going to fight this, and they also caved eventually because there was no way to justify it. Another item that's been litigated is that some judges, when they're appointing class counsel, right, judges can say, I want minority lawyers on this case. A couple of judges had to drop that policy because it's probably illegal now. The example that Justice Kagan uses, and this is actually relevant, what if a judge says, I want to hire minority law clerks for my clerks? Curiously, clerks are not subject to civil rights laws. It's very hard to sue your boss as a judge. You can. It's very hard, actually. What if a judge says, I want to hire law clerks for minorities and a signal? This is actually Kagan's question, the argument, so that black students can become law clerks and can have this path of opportunity. That's why I'm doing it. You know, what if a judge says, I want to hire from Harvard and Yale? Or judges like, don't want to hire from Yale, as some judges do. So I think at least for now, the judges have broad discretion about hiring because they're not subject to these rules, but firms are subject to those rules.
But then what if in the future the judge's broad scope kind of gets narrow and they don't say anything, but they hire?
Just quietly.
Yeah.
Oh, they do.
And,
They
and
do.
you can't, I know that's what we've been talking about, but that's okay. I mean,
It's hard to prove based on intent, right? So it'd be very hard to judges are a bad example, but
or just
And-
even if it's schools or whatever. If
well, that's what Professor Chemerinsky says. Just don't say it out loud. Just do
Yeah.
it quietly. What's difficult is at Harvard, they have like 100 people in their admissions office. It's very hard to coordinate that quietly. There will be a paper trail eventually. With a smaller institution, it's easier to get away with it.
Or if the fellowships, like everyone can apply, but they're not hiring everyone.
Oh, well, that's actually been the follow-up. They actually look at the do this social media, right? When you post the pictures of your class of fellows.
Oh, you can say, oh, there's a trend here.
So look, again, as Justice Roberts said, race is a sordid business, right? There's a virtue in the dissenting view of Justice Jackson and Justice Sotomayor saying, if you're going to do this anyway, may as well be honest about it, right? I actually agree on that point. I don't agree with all of them, but I agree on that point that if you're going to do this, you might as well be honest about it. The flip side is, if you're going to do it quietly, then that gives rise to a bad faith effort to comply with the decision.
But if you're honest, you open yourself up to potential litigation.
Yes, ma'am.
Oh, okay.
So you damned if you, damned if you. I mean, look, and just let me just sort of get to the bottom. I'll come back to opinion. So I actually looked in the numbers of Harvard. You know, Justice Jackson warned. Justice Jackson said, "Time will reveal the results." So from 2023 to 24, that is the first full year this decision was in effect, the percent of black students enrolled dropped from 18% to 14%. So there was a drop. It was noticeable, but it wasn't sort of the catastrophe that people predicted. Asian American representation at Harvard remained about the same, 37%. Hispanic went up from 16 to 14%. That was the undergraduate. I'll give you the law school. At the law school, Harvard Law School, there were 43 black students in the 1L class before the decision. The number dropped to 19, so almost basically half. I didn't go through every college, but at every college, it was sort of varied of how they approached it. And schools have done different things to try to keep their numbers up. But again, the point is, they're still trying to keep a number up, which is what the court said you're not supposed to do. All right. Let me go back to the actual case itself. There's another footnote that I want to just flag involving the service academies. West Point, Naval Academy, Air Force Academy, right? This is where if you want to be an officer in the military, you have to go. This was an important point of the litigation back in 2003, where there was a brief by all these former generals saying, if we don't have affirmative action, we can't recruit minority officers. And we need minority officers to help connect with minority infantrymen, soldiers, right? That was persuasive for Justice O'Connor. Chief Justice Roberts has a footnote saying, we're not considering that now. And oh, by the way, there are distinct interests, word to use, distinct interests in military academies that may be present. So they left the issue open. But now we've seen the last a couple months, all the service academies are dropping their DEI policies. So that issue was being litigated and never really went anywhere. But now we'll see litigation on that front, this end. Okay. Okay, to the compelling. Okay. Now, in terms of narrow tailoring, right? The idea of race is a plus factor. Roberts says the very idea of having a category of just Asian shows it's not narrowly tailored. Why is a person from South Asia treated the same as a person from East Asia? Like, why are those people comparable? They're very different cultures, different languages, different skills. The category of Hispanic, completely arbitrary and defined. It really don't even know what this phrase means. I had students, we talk about the financial aid policy. I had a student apply years ago for a scholarship here. He said he was Hispanic. Indeed, he was. He actually descended from Spanish aristocrats that owned land in Texas for the last 400 years. He actually literally owned, it was before the Republic of Texas was founded. I think it was a grant from the King of Spain. His family traced land. Was he Hispanic? Yeah, he was. It's a category that is at once both too narrow and too broad. I remember Chuck was like, okay, yeah, Hispanic. I guess he fits in the category. Why are we giving him a scholarship, right? It was actually a significant portion of land that was under patent from the King of Spain. It amazes me that you can have land in your family for hundreds of years. I can't even imagine families getting along that well, right? That from generation to generation that kids don't just sell it off. Anyway, where are people from? Someone asked the lawyer from UNC, person from Iran or Egypt, what are they? I'm like, I don't know, right? What box do they check? They just didn't know. Middle East doesn't really fit in anywhere. What's a Jew? I don't know. Am I white? Am I European? Am I Israeli? I don't know. Middle Eastern? What am I? Right? The categories are not in any way narrowly defined. What is black? One parent, one grandparent, one great grandparent. It's largely self-defined, and this creates this kind of perverse incentive where people sort of, exaggerate their racial identities to try and get benefits. It does happen. People lie about their races to get benefits. So perhaps people who might otherwise need it are getting diluted because other people are making these claims forward. Okay. Robert says, the university will tell us, trust us. This is a line, trust us, give us deference. They do not give deference. He has this line, he says, universities may define their missions. The Constitution defines ours. Ooh, he's a good writer. And then he gives a test. I want to just read this test to you. He says, the courts may not license separating students on the basis of race without an, here's the quote, exceedingly persuasive justification. Without an exceedingly persuasive justification that is measurable. That's measurable and concrete enough to permit judicial review. So what's there? There has to be exceedingly persuasive justification for race. It's not just going back to our list, right? It's not just legitimate, substantial. You got to really persuade us, right? Really, really, really persuade us that you need to use this race. And then you must measure numbers, quantify. How do we review that this goal, in fact, is legitimate, right? How do we quantify? Is it concrete enough? You can't just say, oh, we want a critical mass, but we won't tell you what that mass is. Okay. All right. Everyone get that part? Now, what did the dissenters actually advocate? The dissenters are pretty clear they want deference, right? Sotomayor makes this point, as does Justice Jackson. Is the dissenter actually consistent with strict scrutiny? Robert says not. And I think this is an important point. Sotomayor doesn't quite admit this. I think she would say it out loud if you ask her one-on-one. She would only use strict scrutiny for what she might call harmful use of race, right? Plessy, right? Brown segregation, Loving, right? If you're using race to harm people, that goes to strict scrutiny. But if you're using race to help people, Sotomayor says, they would use some lower level of scrutiny, more deferential to the government. Everyone see that point. How does then Roberts respond to this? Yeah. Oh, yeah. He says, it is impossible to help someone with race without hurting someone else in a classroom. There's 100 seats. If you're not in, you're in. Think of Alan Bakke, right? And race, to be candid, was being used against Asian American applicants. The numbers here are pretty clear. Advantaging some, hurting others. Even though, Asian Americans were only, a couple generations removed from Korematsu, right, in this country. Internment. Poor Chinese immigrant come here with nothing, but he's treated depressed because of their grades might be higher. Roberts also says there's a stereotype issue. And here he agrees with Powell, right? When you have these different measures, it presumes that some people are better than others. Also, when you say we need students of this race to articulate certain perspectives, that's a stereotype, right? You presume that a black student will bring something that a white student can't. There's one example using the opinion. Imagine two students from the Upper West Side of New York, a black student and a white student. Their worldviews are probably much the same. Versus, let's say, a white kid from Appalachia and a poor kid from the Lower East Side in Chinatown, right? You presume that a worldview being brought is based solely on race without regard to the person. And he says that's offensive and demeaning, that people of race all think alike. Robert says you cannot do that. Okay. Then he says the numbers here say that if in fact race was being used as one of many factors, you might expect some variability. It might go up some years, might go down some years, right? But in fact, it doesn't. In the decade prior to this case, the rate of black students at Harvard was between 10% and 12%. It was almost perfectly numerical certainty because it operates like clockwork. And they would always have these meetings say, here's the number of minority applicants at this point in the process. To Chelsea's point a minute ago, they were saying the quiet part out loud, right? They were saying what they were doing. Now they just keep it quiet. In fact, the way it works now, at least at most schools, is that the LSAC, LSAC, right? They don't give us the racial numbers until after the student's been admitted and the class is done. So we actually don't see that. It's actually, if you go to the admissions office, you ask them, I checked, they can't even see the information when they're admitting students, right? The checkbox is not visible until the end. We'll get to the essay in a bit, but they've had to reorient the entire way they do the admissions process. I guess you guys started in 2021 or 2022? When did you all start? 23? So, but you applied in 23 or applied in 24?
That was December 24th.
You applied. Oh, so actually, you would have been under this decision.
No, we
January.
December 20. I mean,
Yeah, I know.
I
January.
applied in October 2020.
So you've been under this policy. Okay, you were first. Actually, as a December grad, you were the first policy. Okay. I forgot when you started. Okay. All right. It goes to the 25-year clock. Then we get to, I think, what the heart of the issue is. Does Justice Jackson and Justice Sotomayor really endorse Lewis Powell? No. They don't really care about Justice Powell. Which opinion from Bakke do they resonate the most with? Justice Marshall. And I think this is really sort of the core. This case was never about affirming Justice Powell. No one actually liked Powell's opinion. This is just what O'Connor was able to get 5 votes for. The dissenters argue that there is broad societal discrimination through race, and that the purpose of affirmative action is to remedy that, right? And to be clear, Harvard, if you go back, they excluded people based on race. They had a no Jew quota, right? They limited how many Jews could attend. UNC, this was a segregated institution for much of its history. Now, did Harvard or UNC ever say, we need these policies to remedy our past discrimination? Did they ever say that? No. They didn't want to admit fault, which is kind of interesting, right? They never said, we needed this to remedy past discrimination. They said, we only need this for diversity. So Roberts says, this is John Roberts as well. The universities didn't say they're doing this to remedy their past acts. We won't consider it. You see that? He's so smooth. If you don't pay attention, he'll trick you every time. He says, you know what? Maybe the universities had racist policy in the past, but they haven't raised it as a defense. We're not going to consider it. Oof, Roberts. And he says, by the way, he digs him. He says, if these schools in fact were so racist, we shouldn't be deferring to them. In other words, if this is their history, why are we deferring to them? Why think they're any better right now? There was a very awkward exchange at the argument. The lawyer for Harvard's name was Seth Waxman, who's Jewish. I think it was Judge Alito or Gorsuch. I think it was Gorsuch. And he was saying, so is there any evidence of, Harvard excluding Jews? And the lawyer said, well, we don't do that anymore. This was before October 7th. That one came back to haunt them, I think. That's why I think Harvard's going to hit extremely hard in the current mess. Okay. But Roberts responds, we will not use race. I'm sorry, we cannot allow the use of race to remedy past discrimination. If this institution discriminated, then they can use it. But in the general, right, societal harm. Because why? The poor applicant from Appalachia or Chinatown or somewhere else who had no role in this past discrimination, why are we punishing him for his acts that had no fault of his own? So as a result, the majority said the court, the dissent's not being faithful to Bakke, right? They're defending a vision that was rejected 50 years ago in the Bakke case. What about stare decisis? Right? We'll study stare decisis more in the abortion context. But one of the tenets of stare decisis is reliance interests. Right? That if people come to rely on a decision, even if it's wrong, you leave it in place. And that's actually why the Roe decision was reaffirmed for half a century or for a quarter century. How's Roberts' response to this? He says, well, we gave you a warning shot. We told you Grutter was over in 25 years. Okay, we're 5 years short. Close enough. He also acknowledged that many states have actually banned affirmative action, including California, Florida, and Michigan. So not much reliance interest. When you admit your class next year, you can change your policies. There will be dislocation, right? Policies will be canceled, scholarships, things like that will be canceled also. The court acknowledges. Deal with it. Again, this was the year after Dobbs where they reversed Roe v. Wade. So at this point, sort of decisive thing was kind of like, whatever. And then we get to Justice Harlan, which might be a good place to focus on for a minute, right? Justice Harlan was well ahead of his time. He dissented in the civil rights cases. He said Congress should have the power to discriminate, to fight discrimination. He dissented in Plessy, saying that Congress should have the power. I'm sorry, that the 14th Amendment bar is separate but equal. And if you remember, Harlan said in Plessy that we have a colorblind constitution. A colorblind constitution. And I think I made this point then, I'll repeat it now. That sounds really great when you're in the Jim Crow era, right? Leave us alone. Don't discriminate against us. But the Harlan colorblind sense actually became a little bit unpopular in the 60s and 70s. Why? Institutions said we need to consider race to eliminate racism. This is Sotomayor's primary point. Jackson too. She says we cannot be ostriches, right? We cannot stick our heads in the sand and pretend there is no racism. And the only way to end race is to consider race. We need to have race-conscious measures. Jackson writes, for example, that Harlan knew better. But then Roberts says, no, Harlan wanted a colorblind constitution. Leave them alone. So the issues that they're arguing about in 2023, today, right, are the same issues being argued about in 1898. Right? In many regards, the issues in this class repeat over and over again. And what's changed, frankly, is that the court has a more conservative bend. Justice Kennedy, even though he dissented in Grutter, cast the deciding votes in Fisher 1 and Fisher 2 to uphold the policies. He's not in the court anymore. He was replaced by Justice Kavanaugh. And Ginsburg, who again cast deciding votes in Grutter and Fisher, was replaced by Justice Barrett. So this is an issue in which the court simply just shifted positions. There's not true enough. Grutter had a time limit on it, but it would have been very easy if we had a different court for the court to have said this is consistent with Grutter, go home. Indeed, both lower courts, the First Circuit and the Fourth Circuit, upheld the policy at UNC Harvard, right? Saying we're following precedent, Fisher. All right, questions so far? I'm lecturing more than I do today, but that's the vibe I'm getting. Yes, Sheldon.
I had one on the compelling interest. So now after this, I think the court said the only other compelling interest they recognized was like avoiding race riots in prisons or something like that. So like now, what are essentially the compelling interests that allow race to be considered after all?
Korematsu, which was overruled. This was the worst virtue signaling in the world. This was the travel ban case. The court said, we overruled Korematsu. No one asked you to. It wasn't an issue, right? So in theory, at least Korematsu's out. Affirmative action is out. There's this case, California against Johnson, which is this weird prison case, which Robert cited, but I'd actually forgotten about it. That's how unimportant it is. Like I forgot when I was teaching my class, I forgot about it. So nothing.
Right.
I think the upshot of your question, Shelton, is that nothing justifies use of race anymore after the Harvard case, and that might be it. Right. Again, most John Roberts decisions are very squishy. Here he was steel. Right. He went hardcore. I'll get to the essay bit at the end, which is he kind of watered down a little bit, but most Roberts decisions, I'm always like, okay, there's a trick in here. There's a trap, right? There's a trap door you're gonna fall through. He was like, no, it's not here. And oh wow. And then I'm like, wait a minute. He actually wrote an opinion that coheres, right? There are problems, but he actually had a solid hold. It's not like, oh, but it's actually a tax, right? We didn't get that here. This is a case that he really cared about, and he put a lot of work into. Yes, Ed?
How would you have decided it if you're interpreting Title VI and?
I'm with Thomas. I think the Title VI standard is far more stringent than the equal protection standard. I don't think you have the standards exactly the same. I'll get to the Thomas opinion in a minute. I think Thomas is right almost always, right? But I think at a statutory level, Congress can impose very tight restrictions on its money. We know that from South Dakota against Dole, right? If you take federal money, you better follow the conditions. And I think that's a much easier path than this equal protection stuff. But Roberts wanted a sweeping ruling that applies to everything. He wanted to have a single, one ring to rule them all, right? One standard to rule them all. Is that Lord of the Rings, right? You guys are too cool for me. Okay. If you know that, that's fine. That means you're cool.
No, I got it.
I got it too.
Lord of the Rings is good.
All right. Other questions on Roberts so far? Yes, sir.
Just as far as the law firm thing you raised earlier, would that be Katzenbach, part of Atlanta situation?
Yeah, it's not Title VII, but it's basically Title VII, right? It's basically you can't hire people based on race, and law firms are doing this explicitly for years, and there's lots of receipts, as they say, to prove it.
And they can and federal government can regulate that because of.
Oh yeah. I mean, hiring across state lines, that's easy. Steve?
So like in the I understand like the schools where like we did the switch immediately, but like why is it like we waited till 2025 for all of these other things to start like getting up to speed when this case was in 2025?
Well, Biden was in the office and he didn't enforce it vigorously, right? I was warning schools about this in 23. I was like, look, you may think education is not going to investigate you now. There's a statute of limitation for a couple of years. You might get burned, and this will come back to haunt you. So it's unfortunate. A lot of law firms said, I'll come to the essay part. I said, look, all Robert said is this applies to admissions, and as long as you have an essay about how you're overcoming adversity, you're fine. That was the advice all these schools got. And I'm like, you guys are tripping, right? You really think that's all this case does? And even if you're right into the current administration, what happens in a year and a half if Trump wins? You guys can be screwed. And Harvard is screwed right now. They can't win this. They might win some stuff. They're going to revoke the tax exempt status. I mean, they're not coming out of this one unscathed. Even if they lose a lot of things, it's going to be ugly. The big one's tax exempt status. I mean, these are institutions with billions of dollars in their endowment. These are profitable institutions with no taxes. Property tax exemption, Columbia University, they don't pay property tax in Manhattan. There are some, anyway.
So after 2023, I think that's when this.
Yeah.
There's really no use for strict scrutiny and a formal racial.
Well, there's use for it. It means the law is unconstitutional.
Yes, but not, there's no compelling interest to argue that.
Look, I would say national security still fits, even though they overrule Korematsu. Look, I can imagine that if we were ever in a conflict with a foreign nation and we needed to have some sort of racial measure, I don't know that that's not going to happen. I mean, I can't tell you that, but it's
Just from what they're saying.
yeah. Robert said we're not doing Korematsu. That's gone. Okay, that's fine. They didn't overrule Hirabayashi. Remember the curfew one? They didn't overrule that one. That one's still in the books. That one's still there. Whoops. All right. So the essay part I mentioned before, they say, well, at the same time, everyone agrees that you can consider an applicant's discussion of race affect his life, inspire them, and otherwise. Right? Courage, determination, benefit, your heritage, your culture motivates you to do something, but you must be treated as an individual. And this is the only sentence. I mean, if you look at the email blast that went out, it's like, oh, essays, we're so good. We can do what we're doing. Just shift to essays. No checkbox, we have essays. And I'm like, oh, this is not going to work. Yeah.
So that's not what Chelsea was asking about the strict scrutiny. When the Supreme Court decided the Muslim travel ban case a few years ago, was that the reason for it? Is that not?
So that case is complicated. It was not a strict scrutiny case directly. And the reason why is it applies to people seeking entry to the United States. If you're already here, you're subject to the full Constitution. Welcome. If you're seeking entry, the Constitution does not apply to you directly. That was a weird case where the people bringing the suit were actually Americans who wanted to reunite with their loved ones, whether it was a family member, a university wanted to bring a foreign student, an employer who wanted to hire a foreign worker, or so on. And actually, the basis of those cases was not actually equal protection, because look, all immigration law is based on nationality, right? If you're from country A, you'll get a green card right away. If you're country B, you won't, right? That's how it works. We have express racial quotas for immigration. The base was actually the Establishment Clause, to say that Trump's comments about Muslims actually made this about discriminating against Muslims, so actually it's a First Amendment violation. So it wasn't equal protection, which again made overruled Korematsu made no freaking sense because it wasn't about equal protection. It is Robert's virtue signaling. And the others went along with it. I mean, no one dissented from that point. Thomas went along with it. Yeah, I was in the court, I think I told you this, when they said, and we hereby overrule Korematsu. I'm like, what? I was like, you did what? I'm so confused. Like, why? No one asked you to do that. That was the day that Justice Kennedy would announce his retirement from the bench. Or he would go to the White House afterwards and retire. That was Kennedy's last day in the court. All right. Questions on the majority? Oh, we're out of time. All right. The dissent. And again, when they say principal dissent, the principal dissent is Justice Sotomayor. And then there was Justice Jackson as well. Principal usually means which one's listed first. That's really all it means. Usually more people join it, but it doesn't always go that way. The principal dissent tried to make a few points. So first, the principal dissent said that race is never determinative. That is, that the plaintiffs could never prove that race determined who was admitted, who was not. The most the plaintiffs could do was to show statistics showing, well, here's the percentage for people these grades and so on. In the lower courts, the courts found persuasive that they couldn't show causation. Think of like torts, right? Causation. They couldn't show that race was, dare I say, the proximate cause, right? Was race the proximate cause for admissions? And the lower courts found this persuasive. The majority said that's not the standard. Why? Who bears the burden in strict scrutiny? It's the burden of the challenger to show that race was a determinative factor, or is it the burden of the university to show that race was not a factor used? It's the university's burden. And they said the university could not show race was not determinative. Again, the university could not show that race was not determinative. At most, the record was ambiguous, maybe unclear. And in the case of racial discrimination, when it's ambiguous, the burden goes to the government. They don't meet their government burden, and they lose. Sotomayor and Jackson were actually both trial court judges. This actually matters. If you ever have a chance to clerk for a trial judge, I would encourage it. When you're at a trial court, you learn a lot about making records, about having trials, things of this nature. Appellate judges, they don't care. It's like, oh, whatever, it's in the ether, right? We're all just here to love each other and just talk about ideas. So Sotomayor said, we have a factual record, and there's been no allegation there was an abuse of discretion. These facts are not clearly erroneous. She would say, we are bound by the record of the trial court. John Roberts doesn't care. That doesn't matter to him. He's like, it's like, we're the Supreme Court. We don't care what these little judges do in Boston. It doesn't matter. And this came up more. There was stuff cited in both the majority and the concurrence that probably wasn't in the record, or if it was a record, it wasn't clearly there. And Sotomayor was like, we shouldn't be citing this stuff. And Roberts like, that's good enough. So that's the difference between a trial lawyer judge and an appellate judge. Okay. The biggest sort of part of the dissent, both Jackson and Sotomayor, focuses on the idea of race matters, and that we live in a society that has racial discrimination, which none of the people dispute. And that here the university is taking modest measures to help a group that's been oppressed for centuries. And the upshot of this is that measures that may have helped some people are now going to be deemed illegal. It's not something, let the people decide, debate. The people of Harvard want this. It's a private school, right? UNC is a public school. That's what the people wanted, apparently. So assuming the North Carolina legislature actually has a say over these matters, that's a different story. But at least for Harvard, it's a private institution. All right. The Jackson dissent. Actually, let me do the Thomas first, and I'll do the Jackson dissent after it. Or the Thomas concurrence. So the Thomas dissent is long. I only gave you a couple pages of it. Perhaps I should give you more, but it's a long excerpt. Thomas actually defends the fact that the original meaning of the 14th Amendment does not permit affirmative action. So, for example, we had Reconstruction. We had all these measures designed to help the freedmen, the Freedmen's Bureau Act, and so on. So were those racial benefits? Thomas says no. Those were things designed to help former slaves. So they're not racial, they're based on status. Now, is it the case that all the former slaves were backward African descent? Of course they were. But I think Thomas at least tries to address this issue. Then he basically repeats this line that in 50 years, Harvard and UNC cannot explain the link between racial diversity and educational benefits. It was always just kind of defined a high level of generality with the leadership and opportunities and so on, but there's no concrete data. And that's the key point. Thomas says you have to have concrete data to defend this. What about the fact that this law helps certain people? That might be true, but it hurts others. And there's a zero-sum game with a fixed number of classes, seats in a classroom. You can only admit so many students. Then he responds to Justice Jackson. This is on page 476, and that's probably the excerpt I gave you. Again, it's hard to sort of understand how different these two judges' their worldviews are. Yes, your hand?
I guess back to Thomas's point, why don't these dissents part more on status? Like I understand that the racial stuff doesn't really fix anything. That's what it seems to be, but where you grow up, the neighborhood you grow up in, that can either give you a huge advantage or disadvantage. It feels like they would have a better.
What kind of classification is socioeconomic status? Is it suspect or non-suspect?
Non-suspect?
Yeah, it's non-suspect. So what kind of scrutiny do you get?
It's deference to the government.
Jackson does not want to go that way, right? If it's just based on socioeconomic, then it's what the government wants. No one disputes that, right? No one disputes that you can focus on where you grew up, what your income levels, and so on. No, that's fine to consider. It's truly only race. And sex comes up a little bit in this case, but for the most part, it's close to 50-50 most universities. I think at this law school, we're almost always 50-50, if not 55, 45, but it's rare if you've got guy girl that breaks down. That's how it always breaks down. And we don't do anything to get that number either. It just kind of just shakes out that way. But Thomas makes a point that's very personal. And he says, society is not colorblind, right? But the 14th Amendment must be colorblind, citing Justice Harlan. And he says, even in the segregated South where I grew up, it makes this personal. Individuals were not the sum of their skin color. Not all disparities are based on race. He says, not all people are racist, and not all differences are ascribed to race. Then he says, the legacy of slavery, according to the dissent, locks blacks into a seemingly perpetual inferior caste. And then Justice Jackson responds in dissent. This is a very good line. She says, Justice Thomas's prolonged attack responds to a dissent I did not write in order to assail an admission policy that is not the one UNC has crafted. Justice Thomas has an obsession with race consciousness that far outstrips my or UNC's holistic understanding that race can be a factor that affects a person's experience. Jackson writes, Justice Thomas ignites too many straw men to list. Too many straw men to list or fully extinguish here. Notice straw man is? A straw man is like a fake argument that you can just knock down. Like a straw man, like the Wizard of Oz. Jackson says, insisting that obvious truths be ignored, they prevent a problem or institutions from addressing them. If we can't even talk about racial issues, how can we possibly expect to fix them? Jackson says. She writes that the court turns back the clock. Everyone said that line, turns back the clock? Did you get the reference? In Brown, Justice Warren wrote, we can't turn back the clock to 1868. She's basically saying we're going back to Plessy here. I mean, she didn't say that, but she kind of like needle. There are some very subtle references you have to pick up on if you read the cases closely. She said the court arrests a generational project that they're attempting, but launches a misinformed sociological experiment. And she says time will only tell the results. This is probably of the current court, I think the most useful opinion to get where the justices are. This is the divide in the current court. I think this issue has been settled, at least for next generation or so. We'll see if in 25 years they'll reverse this one, but I think it's unlikely. Yes, sir.
I had a question on, have you seen anybody address this kind of thought? If the dissent, for example, Justice Jackson and Sotomayor are right, and that benefits necessarily flow from diversity, that would mean Black students at HBCU law schools get an inferior education because they're not diverse. They're almost all Black.
Yeah, they're not here for other perspectives. Yeah, I guess that's a fair point. Justice Thomas talked about the HBCUs, historically Black colleges, university, as his Grutter opinion. And he actually makes the point that sometimes people learn better at other institutions, right? There are different ways of learning. But Justice Jackson went to Harvard Law School. I didn't go to Harvard Law School. I couldn't get in there, right? My grades were not nearly good enough, but Jackson went there. And she sees this institution as creating leaders. From her class, how many people became federal judges, became politicians, right? One of my friends, he was in law review with Barack Obama. That's kind of cool. That's kind of cool, right? If you look at the picture of their law review class, like, okay, judge, president, you go down the list. It's a special place. And she sees a role of having people in this institution that can go to the highest echelon of society. Now, I think it's a bit overstated. I think Harvard's overrated, but not everyone goes there as a president. Right? They all think they're going to the Supreme Court. Maybe one of them ever will be.
One of them.
Maybe one. Yeah.
One appeared in Judge Kazimier's courtroom, and it was just fun. I guess I'm going to stop there.
You should. All right. Questions? All right. All right, so let me try to wrap up and give a segue because these two classes are a bit tough. I really can see that. I think you all did well. The standards on racial discrimination, I think it's now been said. I don't know that any law with a racial classification today will satisfy strict scrutiny. I'm not sure what it is. Maybe the prison situation might be an example with prison riots, the gangs. There might be a case involving national security. I don't know, but I think for the most part, equal protection is much more strict than ever was in the last half century. We will do on Monday the equal protection cases for sex. I had a note on a reading for Scrimetti. I was kind of hoping the court would decide the case by this point in the semester, and they haven't. So I won't give you any more reading. You're welcome. I will just talk about the case and sort of bring some of the insights from the arguments from a few months ago. We'll probably get a decision, Scrimetti, probably the last week in June. So you'll all be on your summer breaks enjoying yourselves in Scotland or somewhere else. And we'll go to Scotland? Yeah, enjoy it. Yeah, Scotland. I've never been. Maybe. Okay, anything else? Thank you all. Have a lovely day, and I will see you all on Monday.
Thanks, mate.